The President. Good morning. Let's resume the motion debate on protecting platform workers. Mr. Frankie Yik. President, with the rise of the internet and smartphones, delivery platforms are also on the rise. Back in 2020, COVID struck. People started working from home, and that fueled the rise of such platforms. People could just order things online, and then they could get whatever groceries or food they wanted. Even in the post-COVID era, delivery platforms are still riding high these days. The ingredient of their success lies not just in the diversity of goods on offer, but also the delivery workers who could get the goods to the customers quickly. But that very much depends on the coverage and the size of the delivery workers. The platforms operate 24/7. That means they need a large army of workers. There are peak seasons and slow seasons. When you have too many workers but few orders, that's inefficient. And the same goes for delivery outside district. So the platforms assign orders based on the location of their orders. Workers get paid based on their orders. The more they work, the more pay they get. Orders can come in odd hours, in the small hours, or the order may involve delivery to remote areas. When workers take those orders, they get extra pay. So there is much flexibility. For hard workers with a good attitude, they get extra pay. Nothing wrong with that. Given this great flexibility, and people can work flexible hours, and people are free to switch from one platform to another, and people can work for multiple platforms at the same time. Workers get their commission or bonus within a few days. That's why delivery platforms can attract workers who look for flexibility or people already with another job. Conditions vary from one industry to another, and they evolve with changing market conditions. Insisting on regulation may affect how industries grow. Demand for delivery workers is keen, and that draws illegal workers. These are workers without Hong Kong identity cards, and they use the accounts of others for delivery work. The Liberal Party supports the point that delivery platforms should do due diligence. The same goes for ride-hailing platforms. Those platforms should do the checking to make sure the cars involved have a valid hire car permit. Every accident is one too many. We have heard of delivery workers getting caught up in accidents. They are on a time crunch, but they flout traffic rules. They may even engage in dangerous road behavior. So what we also need is education and tougher enforcement, such as mandatory rules on helmet wearing. And when an accident happens, the people who get hurt should get compensation. Platforms said they wanted to offer protection, but workers come and go. There are freelancers in different industries. A central occupational compensation scheme may have to cover all industries. How do we fund it? What kind of fees, what levels of fees should we charge? This central occupational insurance compensation scheme may run into trouble because a single worker may work for more than one platform. That's a complex matter that warrants an in-depth study before we proceed. I so submit. Dr. So Chen-wing. With technological advances, there are new forms of employment, new services. That means greater ease for the public. And that's very much the result of platform workers putting in the work. But our law struggles to keep up with changes. We lack clarity on rights and responsibilities for platform workers. Platform businesses face keen market competition and also challenges in cybersecurity and trust. Offline collaboration matters. Interests get entrenched over time. There's tension between different factors at play. Better protection for platform workers and regulation and rules for new forms of businesses to thrive need to be balanced with one another, and this is a pressing matter. There are at least 110,000 platform workers in Hong Kong. They're treated as self-employed persons. That means they're not covered by the employment ordinance. 6 drivers went to the labor tribunal for unpaid wages. The tribunal ruled in favor of them. That was the first case for such workers. There are calls for protection for such workers, but each side is sticking to its own arguments. In August 2021, the former Secretary for Labor and Welfare said the government would look into the laws on platform workers in other jurisdictions. 3 years went by. We won't see the outcome of that research until late this year or next year. Platform work will become the new norm in the labor market. There's no going back. New forms of jobs exist, and the law should cover such jobs. We need a legal basis for such jobs, and we have to look after the interests of employers and employees. Whatever aspirations workers and employers may have, the government has the duty to legislate swiftly, to look after both industry interests and workers' rights. Workers and employers should follow the government's guidance. Both sides need to understand the interests at play. There are pros and cons with whatever option we take. There needs to be legislation broadly acceptable to both the employers and workers. On the 10th of September this year, Singapore passed a law on platform workers. There's a third category, an intermediate category, given to platform workers. That's a form of legislative innovation. In April this year, the European Parliament also passed a directive on platform workers. That directive finds there is a relationship between platforms and their workers, where platforms give orders. Those laws elsewhere may or may not apply to Hong Kong, but those are examples of governments taking up the responsibility. So for us, our responsibility should learn from that, and our government should act. I so submit.
Mr. Dennis Leung. Mr. President, I speak in support of this motion debate on protecting platform workers. We need to consider whether there is unfair competition or exploitation in relation to platform work. And if that exists, we need to protect the interests of platform workers as well. We need to bear in mind the important remarks delivered by President Xi on the 1st of July 2022 that we need to break the barrier of vested interests. Mr. LUK Chung-hung's motion referred to the resolution endorsed by the Central Committee of the CPC at the third plenary session on further deepening reform comprehensively to advance Chinese modernization. In particular, items 43 and 44, improving the employment first policy and improving the social security system. One important sentence is here. We need to build a sound social security system for those in new forms of employment and rural migrant workers, etc. Premier Li Qiang called for a regular meeting on the 22nd of November. That's a State Council meeting, and one of the items discussed was about protecting platform workers. It is important to do so in order to promote the development of real economy and promote high-quality economic development. And we also need to help improve people's livelihood and protect jobs. We need to support enterprises to unleash potential. We also need to promote the flow of data for platforms and also align micro policies with macro policies. We need to build a good regulatory framework to promote orderly development of the market so that everyone can benefit from the win-win. We also need to improve the consumption mechanism and the after-sale complaints channel so as to generate jobs. The ILO in September 2018 conducted a survey on 75 countries in relation to the platform workers and platform companies. These platform workers are given treatment not on a par with standard employees. For the working population in the mainland, the platform workers account for 1/4 of the total workforce. So there is a need to adapt to the new forms of employment. The ILO also refers to the existing laws and regulations and the shortcomings in relation to safeguarding the interests of platform workers. For example, the employment relationships are not established. There are no protections in relation to employees' rights and benefits, and including the safety and hygiene and other conditions of the workplace. Now, there are a number of directives issued by the ILO, including 198/202/204. We should make reference to these documents, and according to the ILO, we should set standards and we should also provide the basic safety net for platform workers. We should enhance the scope of social security and promote collective bargaining and enforcing corporate social responsibility on enterprises. I agree with the motion, but I don't agree with Dr. Gan Min-yu's amendment because it is not in line with the objective of the original motion. So we're in the new era. We are promoting decentralization. The algorithm of platforms work behind closed doors, and platform workers are forced to take the unfavorable treatment. We need to do more in order to protect platform workers. Mr. Liang Kwong. In recent years, we've seen deep integration of the online and offline businesses, and platform economy as a result has emerged. And this also drives a change in the job patterns, including the emergence of platform workers. They don't work at fixed locations. Platforms give orders for them to deliver good food and other items. Because of the flexibility, the job has an appeal. According to information over 110,000 people in Hong Kong work as platform workers. But I also learned from media reports that a platform worker ran into a traffic accident, and as a result, he got compensation fewer than $10,000. Now, my alliance have issued a document calling for more protection for platform workers and that the Hong Kong government should do more to protect them. Now, for major platforms, the workers under them work as self-employed persons. They do not have a minimum wage and they don't have MPF contributions either. They need to take out personal insurance. Now, for labor insurance, the maximum compensation amount is $3 million. Now, for the two major food delivery platforms in Hong Kong, the insurance coverage is only up to $500,000, and the claim must be made within 30 days. Coverage is limited to the period when they're online or 1 hour before and after that. In other places, there are laws to clarify the legal status of these workers. For example, in Singapore, they have the Platform Workers Bill, which promotes a setting up of a central provident fund to protect platform workers. In Hong Kong, we don't have the relevant legislation. In 2021, the government once agreed that a study should be conducted to enhance protection for platform workers, but no progress has since been made. It's been 3 years, and it's difficult for platform workers to pursue their claim. Now, platform work has the appeal as it is flexible. However, is it really as flexible as the platform companies claim? For example, for one of the platform companies, the workers may choose when to get online and choose what orders to take. But if the number of orders received is lower than a certain threshold, then they have a lower rate. They have a lower chance. And customer rating also determines what group that they fall in. If they're in the lower group, that means other platform workers will have priority in choosing orders. So they do not enjoy as much flexibility in reality as the job ad claims. They are not. They don't enjoy the rights and benefits as a self-employed person. Now, a number of work strikes took place. Last year, some platform workers also filed a claim with the Labour Tribunal for wage arrears. They were rewarded with compensation because the Labour Tribunal is of the view that this is an employment relationship. That is why the government should collect statistics and conduct survey on the number of platforms and platform workers so as to draw policies to protect their rights. For example, there should be a clear delineation between self-employed person and those working for platform companies to avoid workers being exploited by the major platforms. This can help solve the problem of false employment. Ms. Eunice Yong, I speak in support of Mr. Michael Luk's original motion on protecting platform workers. Platform economy has emerged and developed very rapidly in Hong Kong. According to a survey, there are 5 major platform companies in operation in Hong Kong, and over 114,000 people work for these platforms that accounts for 3% of the total workforce. But they are not given sufficient labor protection. Platform workers in Hong Kong are in a predicament, and this has sparked the community's concern. In recent years, we've also heard about wage default cases and their inability to file claims. That's because they are often considered self-employed persons. They do not enjoy the benefits and entitlements under the Employment Ordinance, and they are also given unfavorable treatment in terms of their work conditions, and that is why we need to enhance protection for them. In Zeek case, the Labour Tribunal offered important insight on the employment relationship. In other words, For the first time, the case confirms that for platform workers and platform, they have the relationship as employees and employers. Now, the platform's app exercise control over the platform workers because platform workers receive orders from the app, and the company could also exercise control and supervision over the platform workers, including the routes of delivery, their locations, as well as customer ratings. So the system imposed by the platform company shows that the platform workers are de facto employees, and the employment relationship is therefore established by the Labor Tribunal. In fact, not all of them are self-employed persons. There is also the problem of false employment. The platform, well, we need to determine the nature of work. It should not be unilaterally decided. However, if we need to seek the court's direction on whether this relationship is an employment relationship, then it's not practical. In other jurisdictions, they have enacted legislation to protect platform workers. For example, in Spain in 2021, they passed the Riders Law, which means that platform workers are considered employees of platform companies. In September, the Singapore passed the Platform Workers Bill. It will come into effect on the 1st of January 2025. It covers food and goods delivery workers and ride-hailing drivers, and they are given protection under the Central Provident Fund. Now, in light of this global trend and the challenge, we should also be innovative in enacting legislation. On top of amending the legislation, the government should provide more support to various industries to promote the development. I understand that the Labor and Welfare Bureau and the Labor Department have updated their response after the Labor Tribunal's case in response to the calls in the community for a level playing field for platform workers. So we should provide the platform workers with training, and that should also be a platform to seek views from stakeholders and practitioners in the industry. Platform economy has formed a new mode of economic activities. It generates a lot of jobs. Conventional labor protection mechanism may not offer sufficient protection for them. As a responsible government, we need to tackle these issues. Whilst promoting the development of enterprises, we need to safeguard labor rights so that every worker can get a share of the fruits of economic success. I so submit.
Mr. Lam Chen-sing. Thank you, President. In Hong Kong, most frontline platform workers, say food delivery drivers, goods delivery drivers, are considered to be self-employed persons. They don't enjoy interests and rights of employees, and they are also affected by the algorithm of the platforms, so they do not enjoy the autonomy and flexibility as other employees do. So it's a lose-lose situation to them. The FTU conducted a survey on platform workers. A total of 300 food delivery workers were interviewed. There were also some from ethnic minorities. Some said that they got injured during work, but then they did not receive any compensation from platforms. 6% of the respondents said that they had suffered from work injuries, and there were compensations offered by the company. 54% of the respondents said that the platforms offered insufficient insurance coverage for them. 71% of the respondents said that their identity should be clearly defined. 66% of the respondents are concerned about work injury compensation. The government is not quick enough to protect platform workers. It started a survey in 2021 and it's been 3 years since. Only next year will we see a thematic household survey on platform workers. If there are measures based on the findings of the survey in the future, I believe there will be it will take a longer time for us to see measures. In Singapore, however, it only took 3 to 4 years. In Singapore, the Platform Workers Bill was passed. Work agreement was entered into between employees and the platform companies. If there is such an agreement and an element of control over platform workers, then there will be a legal status of employers and employees. Then these workers enjoy some of the benefits as an employee. For instance, platform companies need to take out work injury compensation insurance policies with the same level of coverage as employees. Companies also need to make contributions to the Central Provident Fund Savings Scheme. Platform workers may not need all benefits, say leave, maternal leave, and so on. Otherwise, they would have already chosen a full-time job. They want to maintain flexibility, but then some of the work nature is similar to that of an employee. If they have any accidents, but then they do not enjoy work injury compensations, that is not fair to them. So in Singapore, there is a new identity between a self-employed person and an employee, which allows these workers to enjoy work injury compensations. At the same time, there is no too much of a financial burden on platforms. A balance can thus be struck. We have the Employees' Compensation Ordinance within the laws of Hong Kong, and we also have the MPF system. As long as we define the identity of platform workers in the laws of Hong Kong, then we can protect platform workers. We need to set a timetable. We also need to formulate measures to improve the benefits and treatment of platform workers. President, I so submit. Mr. Chow Siu-chung. Thank you, President. Platform workers, including online food and goods delivery workers, do not enjoy sufficient protection under the laws of Hong Kong, as they are stuck between a self-employed person and an employee. Platform companies seem to be flexible, but then they exercise control and algorithm to exercise control over the mode and income of platform workers. Under the existing labor legislation, platform workers are only considered self-employed persons. Work injury cases, retirement benefits, there is no such protection at all. The Labor Department has been in communication with platform companies and discussing protection for platform workers, but this is not effective enough. We haven't yet resolved the problem in relation to work injury cases yet. Food delivery workers and platform workers need to work, rain or shine, in the streets. They are prone to any accident on the streets. But platform companies only take out group medical insurance policies for these workers. They don't enjoy the same level of benefits as employees. The maximum benefits of death and work injuries range from $200,000 and $500,000. In case of serious work injury accidents, this compensation amount is not sufficient. Platform companies also exercise algorithm. There is a time limit for each order. Workers lose the bonus if they go beyond the time limit. No one knows the exact operation of algorithm, but platform workers feel that their time has been reduced. Foot soldiers need to run or they need to ride a bike. Those who ride a motorbike are forced to speed or run a red light. So they make the impossible possible. That's why the algorithm further compressed the time limit, and this formed a vicious cycle. That's exactly why we see traffic accidents happening. We need a system to protect platform workers. Platform companies need to shoulder the responsibility. At the end of 2021, the Labor and Welfare Bureau said that they are looking into the situation in other places. After a few years, we haven't yet seen a clear direction. In 2021, mainland China issued guiding opinions on protecting labor platform workers, including taking out social insurance policies. This year, we have the guiding opinions once again, protecting reasonable benefits for platform workers. Since 2021, Singapore has formed the Platform Workers Consultative Committee. September this year, they have passed the Platform Workers Bill, which will come into effect starting the 1st of January next year. However, Hong Kong hasn't yet announced any findings of the survey. We haven't yet made any real progress. We should set a new category of platform workers, and we should also ensure sufficient benefits, say retirement benefits for platform workers. We also need to enhance the communication channels between employers and employees in order that they won't be affected and their benefits won't be deprived of. Dr. Tan Yue-hung. Thank you, President. Platform company is a new form of employment. It has changed our lives. It not only brings convenience to our lives, it also brings into being a new form of employment that is highly flexible. So workers receive flexible and short-term income. Take food and goods delivery platform as an example. Platform workers sometimes break the relevant law. They breach road traffic ordinance, and it will be difficult for them to ask for their rights. Some ethnic minorities work on these platforms because of a lack of information or language problems. It's difficult for them to file a complaint and make a claim. The stronger a platform, the greater the need we need to control the platform. We need to draw reference from the experience of other places to have the relevant legislation to protect the legal labor rights of platform workers in order to ensure the sustainable and healthy development of the industry. So I speak in support of Mr. Michael Luk's original motion. I have 3 suggestions. We need to legislate to protect the platform workers working in Hong Kong. We also need to define their legal identity. This new form of employment is a challenge to the traditional employment. From online food delivery to online goods delivery, their work is fragmented. However, they are also subject to the control of the platform companies. However, they are considered self-employed persons. In many places, there is legislation distinguishing between employees and self-employed persons or platform workers. They may enjoy leave benefits, but then there may not be work injury cases. In 2021, Spain confirmed the status of online food and goods delivery workers. In 2021, Singapore passed a platform workers bill and confirmed the provision of Central Provident Fund Savings Scheme. These experiences are worth our exploration. We need to amend the employment ordinance to define platform workers and include platform workers into the coverage of protection. There should also be a tripartite collaboration. With digital platforms becoming more and more popular and common, there is a great demand for these services, but then there's a lack of quality control of these platform workers. This year, some two-way permit holders or those non-Chinese people holding or subject to non-refoulement claim are affected. They are not familiar with the situation in Hong Kong and then they break the law. So the government needs to shoulder the responsibility of regulating the situation. Efforts should be stepped up to clamp down on illegal workers. There should be an identity registration scheme for platform workers. We need to ban illegal workers at source. I so submit. Thank you, President.
Mr. Kitson-Yang. Thank you, President. I support Mr. Michael Luk's motion on protecting platform workers. We have discussed this topic many times. Platform workers face many challenges that those have been covered: sham self-employment, lack of protection, among others. I think the government knows what the problem is. Platform workers are styled as self-employed people, but they are really in an employment relationship with the platforms, and these workers should be covered by the employment ordinance, employees compensation ordinance, among other laws. The need is to strike a balance between the interests of platform businesses and their workers. For workers trying to stand up for their rights, they have to go to a tribunal or a court. Last year, workers were owed wages by platform, and then the labor tribunal ruled in favor of an employment relationship, and the platform was ordered to pay wages, payment in lieu of notice, and holiday pay. Platform workers are not self-employed people. In that case, the drivers won, but that ruling does not apply to all platform workers in Hong Kong. Not everyone can get justice. Over the past 2 years, there were 3 cases, 3 complaints where workers were exploited under the pretext of self-employment, and the investigation could not proceed because of lack of evidence. And in some cases, the platforms exploited their workers. They did not have to take responsibility as employers. Now, the gig economy is becoming more widespread. Gig workers will make up half of all American workers. In Hong Kong, as of 2022, we had 220,000 self-employed people. That's 6% of our 3.65 million workforce. More people will become freelancers. Gig workers now cover not just delivery workers, ride-hailing drivers, but also to other industries, construction industries being one of them. The government needs to think through ways to strike a balance. I know the government has been watching the approach adopted elsewhere. The mainland and Singapore rely on negotiations between employers and workers. The mainland issued guiding opinions on protecting the rights and interests of people engaged in new forms of work. So those guidelines cover rest hours, pay, conditions. Last year, a delivery platform entered into a collective contract with its workers. That was the first. And then in Shanghai, a dispute resolution center was set up. The U.S. has taken a similar approach. New York proposed bills on the minimum wages for delivery workers. The UK Labour Party has also proposed a make work pay plan. Elsewhere, there are efforts to protect the rights of platform workers, but their success remains to be seen. The platform economy provides convenience for consumers, business for enterprises, but platforms are in the position of control. We cannot be blind to the problems involved. The government should play a more proactive role. Let's learn from the mainland and elsewhere, and then we come up with measures in line with our local conditions. Before a legislative amendment, we should consult widely. We can consider an online platform for people to report irregularities, among other measures as so submit. Mr. Chen Xiu-hong. As the internet becomes widespread, related industries evolved rapidly. Platforms came into existence. There are now new ways to tap into idle human resources. The platform is there to bring together different parties. There are transaction-based platforms and innovative platforms. Didi, a ride-hailing app and platform in the mainland, is an example. And then you have Airbnb overseas. Freelancers also take jobs in illustration through platforms. These are all examples of platforms. Now, food delivery involves linking up businesses, in this case restaurants, with customers. These new forms of business, enabled by the internet, works for businesses and also create flexible jobs. With the platform economy, socioeconomic problems arise. One such issue is protection for platform workers. Protecting platform workers and ensuring the vitality of the platform economy will be a balancing act, and this will be a challenge. We have to guard against overkill so that we do not stifle the platform economy. Mr. LUK Chung-hung is moving this motion. Mr. Wai-keung and Dr. NGAN are moving amendments. In principle, I support them, but I do have reservations about the amendment from Mr. Wai-keung. Given the flexible nature of work, it's a contentious matter how we should regulate it. The member proposes a central occupational insurance compensation fund. A handful of rule breakers may lead to soaring premiums. In the end, the extra costs are passed on to businesses and consumers. Higher compliance costs means less competitiveness for the businesses. On the fair allocation of orders through algorithms, this is about protecting workers' rights from unfair algorithms. Again, I support the direction. But in practice, there will be technological challenges. Different platforms design their own algorithms in line with their own market and conditions. This is about optimizing resources. Government intervention in the design of algorithms will have a major impact on the business, and this will hurt the competitiveness and vitality of the business. The fairness of algorithms is a highly complicated matter. There is no consensus. This also involves massive resources for monitoring and policing. Strict regulation of algorithms will result in regulatory overreach. For platforms seeking to enhance user experience, they will face massive constraints. And that will make life difficult for tech startups. This may lead to monopolies. In the end, this will hurt the platform economy. I support Dr. Frankie Ngan's amendment, which argues for a full review of the employment ordinance and related laws. And we should also learn from the law in Singapore. We should clarify the legal status, obligations, rights, and interests of platform workers so that we protect these workers and foster the platform economy. I so submit. Mr. Peter Xu. Thank you, President. The motion is about protecting platform workers, moved by Mr. Michael Luk. On the 26th of August 2021, Mr. Michael Luk also brought up a motion. It was about protecting the interest and rights of platform workers. Mr. Wai-keung and Mr. Poon Siu-ping amended the motion. All amendments were voted down. Electrical research came out in 2023. 5 major platforms in Hong Kong, Uber, Didi, Google X, Foodpanda, and Deliveroo, have an army of 114,000 delivery workers. 50,000 workers work for Uber. Now, but ride-hailing is not legal, so let's leave it at that. Today's focus is on delivery workers. The crux of the matter is the definition of self-employed persons. Why do people choose to be self-employed rather than seeking employment with the business? Self-employment offers flexible work hours. People can work only when they choose to. People take jobs only when they want. That's flexibility. Not every business can hire all the workers they want. Say for me as an electrical member, I cannot hire a designer all the time. That's just not cost effective. So I contract out the work to freelance designers. For ride-hailing, food delivery, restaurants do not hire their own delivery workers because these businesses cannot afford it. That means there's room for such delivery businesses. Self-employed people may prefer flexibility in hours and what jobs they take. Meanwhile, they also want all the benefits of employment. If this had worked, then all my work-own employees would ask for self-employment. This is a problem with the market. Now, insurance. I also agree on the need for protecting these workers. Self-employed people on motorbikes have insurance coverage, but that coverage excludes business. So for riders, do they have coverage for themselves and third parties when they're in business? We can agree on the need for study into the matter, and we should take swift action on that. Giving self-employed people the full range of employment rights, is that something self-employed people want? Mr. Lam Chun-sing said he surveyed 300 people. The survey was about businesses and people. That survey contained a question of whether those self-employed people wanted to be employees rather than self-employed people. These people may not want to become employees out of their own volition. And if we do proceed with such a legislation, what are we doing? What are we trying to achieve? Mr. Wai-keung mentioned he wasn't happy with the allocation of orders with algorithms and the reward and punishment. We believe in making work pay. We stick to fairness, but that is not the same as egalitarianism. We want platforms as new quality productive forces involving technology. We want that industry to thrive. Excessive regulation goes against new quality productive forces. I invite the Secretary to think about this.
Ms. Connie Lam. Thank you, President. I speak in support of Mr. Michael Luk's motion on protecting platform workers. We're in a different generation. Our parents might work in the same job position for their whole life. But nowadays, young people prefer flexibility and autonomy at workplace. In recent years, a new type of employment has emerged. They're called slashers. They are the typical platform workers. They usually work as food delivery workers. However, they don't have a say over how they're treated. For platform companies, the biggest problem lies not in staff wastage, but market share. That means platform workers are trapped in a handful of major platform companies. They do not have any bargaining power. Take Hong Kong as an example. There are two major food delivery platforms. They are accused of monopolizing the market. For example, they draft contractual terms limiting the choice of restaurants. They also resort to means to stop other market players from market entry. Customers are not able to enjoy the benefits from market competition. Slashers work in a flexible manner, and they do not have any focal point. They don't have bargaining power. They do not enjoy the benefits as a self-employed person. After the work strikes in 2021 and 2022, last month we saw another round of work strike by platform workers. They called for better treatment, and they called for a stop to the algorithm being used. However, the government has been very passive. The government hasn't enacted legislation, and as a result, the relationship between platform workers and these platforms remain vague. Many slashers are the foot soldiers for these platform companies. They may be riders, and they're prone to traffic accidents. In recent years, we've seen a spate of traffic accidents. They don't get protection as employees for these platform companies. That is why I agree with Dr. Yu that we should comprehensively review the employment ordinance and make appropriate adjustments based on the changes in the market, so as to clarify the legal status, obligations, rights, and interests of enterprises and platform workers. In the mainland, platform companies are developing very rapidly, and it serves as our reference. For example, we can have government intervention. I think that platform operators should be more active in shouldering their governing responsibility. There should be more protection. Platform companies should be given more autonomy. Only when it's absolutely necessary should the supervisory body should step in, and the pilot scheme on mediation in the community will be introduced soon. Following that, we can also have the conflict resolution room in the community. So as to enhance the sense of happiness and sense of achievements for gig workers, I support the motion and Dr. Yu's amendment. Mr. Sunny Tan. President Xi Jinping on the 31st of October published an article in the magazine Qiu. In this new era, there is a new mission and a new position. We need to promote high-quality development and promote jobs. We need to be people-centric, and also the government should take the lead in promoting employment. According to the recent report published in May this year, over 10% of young people in Hong Kong would like to be self-employed so that they enjoy more flexibility. 85% of full-time youths have a full-time job as well as freelance job. For food delivery workers, many of them have full-time jobs as well. They want to earn extra income, so they become food delivery workers for platform companies. I believe that every person should be given the liberty to choose what jobs they prefer. I think Hong Kong people are smart. For the underperforming platforms, they will naturally be phased out by the market. Item 43 of the resolution passed at the third plenary session refers to improving the employment first policy, and that is we need to improve the system of employment support to address or tackle structural employment. In other words, there's a mismatch in the job market. In June, our country conducted analysis and published an article that is, we need to solve the conflict between the job opportunities for skilled workers in order to promote high-quality development. According to the Labor and Welfare Bureau's information, that is a manpower projection in 2023, that there will be manpower shortage in the long run. We need to train skilled manpower to cope with the new forms of employment. In September 2024, according to the guiding opinion published by the country, I think that we should refer to the theory published, and that can be applied to Hong Kong. I'm happy to learn from the policy address that the ERB will be revamped to cope with rising social demand, and that the education and manpower policies will be reviewed so as to increase coverage of training in tertiary institutions. For example, we need to have a proper employment policy to unleash the potential of the silver-haired group. For popular subjects and disciplines, more such courses should be operated. We also need to cut resources for programs no longer needed in order to address the manpower mismatch issue. According to the Chief Executive, we need to benefit the people. We need to aspire to the needs. I'm sure that we should all respect the life choices of our people. We should improve a top-level design in order to benefit the people. Mr. Stephen Ho. Thank you, President. I thank Mr. Michael Luk for moving this motion. Post-COVID, we've seen a new form of business, and that's food delivery platforms. Although, according to one of the delivery platforms, they are celebrating the 9th anniversary, so it's not really something new anymore. This is a new form of business, and there are new problems. Now, Dr. Ng Yu refers to what we've been discussing, and that is the traffic accidents involving riders. And we're talking about whether they are self-employed persons. And I think time is ripe for us to review their legal status. Despite years of discussion, we need to take the matter forward. We can't have an impasse here. Now let's call them riders. Are they sufficiently protected? What should be done to make platforms offer more protection for them? This could be the original intention of Mr. Michael Luk. I think the crux of the matter is to protect riders for platform companies. In fact, in the past, we had a similar form of job types as well. For example, for the so-called white license vehicles, ride-hailing online platforms, they claim that the drivers have their own have protection. But we also have taxi drivers driving legitimately in Hong Kong. Now, for food delivery platforms, and I'm thinking about 3 to 4 of them, they have different policies when it comes to the riders. Sometimes I hear about complaints that it's difficult to authenticate the identity of the rider. For example, I live in Yuen Long, and I thought that the driver would be Putonghua speaking. In the end, the rider who arrives is a Southeast Asian. So I think for consumers, we're concerned about the quality of service and the identity of riders. Another point I'd like to make is this. Now, Mr. Wai-keung refers to algorithms in his amendment. But the platform is, after all, a business, is a company. I think it's difficult to compel a company to disclose how they are disbursing bonus payments. We can't do that through legislation. Now, they may make use of the algorithms to improve the quality of service and the quality of the riders. And it's not just about protecting platform workers or riders. It's not enough an incentive for them to improve the algorithms. So I'm looking at the motion and the amendments, and I see diverse views. Still, on this topic, I don't think the Labor and Welfare Bureau is sufficient. You should talk to the CEDB to improve the CSR initiatives so as to protect the riders better, so as to resolve the conflict. Because if everybody's happy, I don't think at the moment it is a big problem. People are offered jobs, they make ends meet, they have flexibility, they can choose whether to work today or not. So from the platform's perspective, I think that perhaps they should have a new mode of operation or not. Still, I think that this is just an emerging form of business.
Mr. Bill Tang. Thank you, President. We need wisdom to solve this problem. It's not about what is right or wrong. We need to solve the problem. I listened to Mr. Peter Schill and I paid close attention to him. He mentioned a key point. That is the occupational safety protection. When there are accidents, the injured workers will always fight for the greatest protection. They will take the case to the court of first instance, or even the court of final appeal. I believe many of you are well up in a case in the Privy Council. The accident happened in a golf course. A caddy got injured in that case, and the injured workers always want to have the greatest protection and compensation. There was an accident in a concert. I thank the government for looking into the case. The dancer was considered an employee. We want the administration to be people-centric. We need to be people-centric in relation to all cases, including the one I mentioned above. We can draw reference from some cases, say domestic helpers. Who are the employers? Is it the NGO? Or is it the family that takes on the domestic helper is the employer? Before this position came into being, many foreign domestic helpers were imported into Hong Kong. That's why we have local domestic helper. So when a family pays hourly wages to the domestic helper, the family also needs to take out a short-term insurance policy for the helper. As long as there is a policy, then there won't be any disputes. Say I have worked for a family for a long time, I need to fight for this and that, say leave and so on. When there are accidents, then one is protected by law, which is a far cry from work injury compensation. Let's not talk about the third form of employment that we need to explore. Take some countries in Europe or Singapore as an example. There will always be a new tactic when companies do not want to own up to the responsibility. In the UK, they call these workers worker. The government should take the lead and discuss with the major platforms in Hong Kong. We need to explore using short-term labor protection insurance. Then I believe every one of us will have peace of mind. Just now, Mr. Peter Schill mentioned we want to see protection whenever there is an accident. When we get in touch with platform workers, this is exactly what is the closest to their hearts. It's not about paid money or paid leave or sick leave and so on. For the existing mode, a platform worker can work for more than one platform. We need to deal with work compensation using the case of domestic helpers. We need to talk to the major platforms in Hong Kong. If we have short-term work insurance policies, then we can solve the problem. Thank you, President. Mr. Kingsley Wong. Thank you, President. How can we protect platform workers? How can we ensure a level of protection? We should draw reference from the mainland. In 2021, 200 million workers are flexible workers. Quite many of them are platform workers, and there are 4.7 million drivers working for. They work for Meitun in mainland China. The NDRC issued in 2021 a guiding opinion on protecting labor and social security rights and interests of workers engaged in new forms of employment. It confirmed the legal status of employment, and where there is an employment relationship, there should be an agreement entered into between employers and workers. Say, if workers are defined as working partners, then they will lose the protection. Even if there is a group insurance policy taken out, the compensation terms are still a far cry from those of work injury compensation. Every week, $3,900 at most, and it is kept to 5 weeks. Companies distribute orders to workers on the app and paid wages directly. Platforms should shoulder a greater responsibility. Workers engaged in new forms of employment should be protected. Alongside the trend to go north for consumption, some workers go online for 10 hours, but they still cannot earn the minimum wage. There should be additional clauses like workers need to go online for a long time. We also need to clamp down on illegal workers. 2 of the major platforms use face recognition technologies. Those illegal workers holding reconnaissance forms are common. The government needs to ramp up efforts to clamp down on illegal workers in Hong Kong. The rest environment of platform workers also deserves our concerns. In the mainland, there are pit stops for platform workers to take a rest, to charge their mobile phone before they go to work again. We have finite land resources in Hong Kong, but if we can make space for such pit stops underneath bridges, then we can also let these platform workers take a rest. Say, community living room can also be used to provide a place for platform workers to take a rest. In some public housing estates, vehicles of platform workers are towed away, or they are not allowed to park in the public housing estates. There should be short-term parking spaces for platform workers. We only need 100 square feet or so. In some public housing estates, there are spaces for bike sharing platforms. I speak in support of Mr. Michael Luk's motion.
Does any other member wish to speak? Mr. Michael Luk, you may now speak on the amendments. President, I'm speaking on the amendments. First of all, I thank 2 members, Mr. Wai-keung and Dr. Yu, for moving amendments to my motion. Let me first respond to Dr. Yu's amendment. I think he's adding to my motion. Now, My motion refers to expeditiously regulate online food and goods delivery platforms. NGAN Yu's amendment suggests comprehensively reviewing the employment ordinance and related legislation to expeditiously clarifying the legal status, obligations, rights, etc. of enterprises and platform workers. I think the two can go hand in hand to achieve high efficiency. Because at the moment, with the emerging mode of business, there is ambiguity. It's not a conventional employment relationship as such. There is a gray area. And apparently, the platforms make use of algorithms, big data, analytics to exercise control. It has in place a reward and penalty mechanism. It has as much control over the workers as a typical enterprise. So I think we need to explore whether this is indeed right. In Singapore, they define the workers as this term worker, so we can perhaps make reference to that as well. Now, as for my fellow party member, Mr. Wai-keung's amendment, he elaborates on the FTU's proposal to enhance protection for platform workers, and he takes my motion further. In this preamble, he explains what happens at present, and that is they are not given sufficient labor protection. These platform workers do not really enjoy work autonomy like traditional self-employed persons. So communication and negotiation are very important. But if there is no statutory mechanism, that means everything will remain on the drawing board for good. So he proposes establishing a statutory tripartite negotiation mechanism. I believe that this mechanism can help solve problems and conflicts. These conflicts may pose hurdle to the healthy development of this business. It may become the deterrence for people who'd like to join the market. So a tripartite negotiation mechanism can promote development of platform economy. Now, members have diverse views on point 3, targeting illegal workers. So the platforms should put in place authentication mechanisms to prevent account rental and illegal workers. The diverse views come from different members. For example, whether a central provident fund should be set up and how the parties should make contributions respectively. We can explore these further, but we need to start somewhere. That is to say, we are concerned with the protections for platform workers, for food delivery workers, be it walkers, riders, bike riders. In the event of a traffic accident, it could be fatal. So I don't think we should dwell on whether it should be called a Central Occupational Insurance Compensation Fund. We should support the idea. Now, about adopting algorithms or making the algorithms open to the public, after all, is commercial secret. But like the practice in the mainland, we should set the bottom line. We should draw up code of practice for the platform companies. Because the algorithms act in a way that make riders and walkers to violate traffic rules. I don't think it works. Now, the key is to put in place suitable disclosure of algorithms. Please stop.
Secretary for Labor and Welfare. President, once again, I'm grateful to Mr. Michael Luk for moving this motion, Mr. Wai-keung and Dr. NGAN Yu for their amendments. A total of 28 members have spoken on this issue. I'd like to thank members. I will respond from the perspective of the Labor and Welfare Bureau. Basically, members are concerned about the identity of platform workers as well as the level of protection and its direction. Some members are also concerned about the issue of illegal workers. I will respond to these issues. On the identity of platform workers, the original motion moved by Mr. Michael Luk and the amendments moved by Mr. Kwok Wai-keung and Dr. Ngan Yu also describe the identity of platform workers. Some said they are workers engaged in new forms of employment. Some said they look like self-employed persons, but they aren't exactly self-employed persons. Some also said they may be working partners. But members agree that we need to clarify the identity of platform workers. In this regard, the Labor and Welfare Bureau subscribes to your views. Comparing with traditional employment relationships, platform work is highly flexible. Workers can go online to provide service for the platform according to their schedule. However, there are also views that platform companies impose regulations and control of varying degrees on platform workers. Therefore, they are not as free as a real self-employed person is. The agreement terms between a platform company and workers vary from one company to another. It may not be proper to define them as employees or self-employed persons across the board. These unique circumstances show the difficulty in defining the identity of platform workers. It is also suggested that a new category between employees and self-employed persons be created, but we cannot assume that all platform workers fit into this new category. Setting out the proposed protection as well as the rights and interests for this new category is no easy task. We must consider them in detail. The government has stressed that whether the genuine status of a person is an employee does not hinge on the post title or contract title, but hinges on the actual circumstances of his or her provision of services. Court cases set out a series of criteria or factors for consideration for weighing to determine the status of a person. As one of the members said, in a case in a concert, a worker was considered to be an employee, not a self-employed person. The Labor Department provided a special consultation service since December 2022. The above criteria and factors are simplified into an easy-to-understand pro forma on assessment of working status to help inquirers to distinguish that job nature relates to that of an employee and a self-employed person. It takes only about 10 minutes to finish the pro forma. Then, you will be able to tell whether your job nature relates to that of an employee or a self-employed person. If there are any disputes involving suspicions of false self-employment, the Labor Relations Division will provide conciliation services or, at the request of the claimant, refer the case to the Labor Tribunal for judgment. On the level and direction of protection, an employee enjoys labor protection as an employee. But in the long run, we do not want platform workers to initiate litigations before they can enjoy statutory interests and rights. That said, any legislative means to enhance the protection of platform workers must be seriously considered. How much protection is sufficient or reasonable varies from one person to another. Those who engage in platform work full-time may not have the same expectations of protection as the platform workers who only go online in their leisure. Furthermore, the new interests and rights that platform workers enjoy after legislation or legislative amendments will definitely bring them new responsibilities. It is inevitable that their work autonomy may be reduced. Platform workers who enjoy autonomy may not welcome this change. On a different note, we need to strike a balance between the interests and rights of platform workers and the affordability of a platform company. Otherwise, the overheads will rise and will be passed on to platform users. This may impact on the development of platform economy. Therefore, we need to take some time to grasp the actual situation. The Labor Department has been taking forward work on this front. It draws reference from overseas experience and trends, while at the same time it tries to grasp the data and situation of local platform workers. Turning to overseas places, the EU tried to devise a set of criteria that is applicable to its member states to determine whether a platform worker is an employee. After several years of discussion, however, it was only decided that member states could enact their own legislation in 2 years. In addition, Singapore established that platform workers who engage in delivery and ride-hailing services enjoy certain legal protection. However, in the meantime, it is expressly indicated that platform workers are not employees. In the UK, aside from employees and self-employed persons, there is another identity. They call it worker. But whether a platform worker is a worker depends on the actual circumstances of each case. To explore a direction that is suitable for Hong Kong, the Labor Department has commissioned the Census and Statistics Department to conduct a thematic household survey. It collects objective data such as the characteristics and work conditions of local platform workers. We have already finished collecting the data, and we are analyzing these data. Moreover, the Labor Department conducted online surveys and focused group interviews on platform workers in the third quarter of this year to collect their views. The data are being analyzed as well. At the same time, the Labor Department has set up a liaison group to facilitate tripartite communication and collaboration among platform companies, labor groups, and the government with a view to coming up with feasible proposals to realize a tripartite coordination mechanism. On the 26th of November, the Labor Department and its liaison group held a forum together with the representative of platform companies as well as labor sector, including Mr. Michael Luk and Mr. Wai-keung. In the forum, participants put their heads together, and scholars as well as insurance professionals were invited to share their views. In the discussion session, there were 3 core areas, including accident compensation, communication mechanism between platforms and workers, and forbidding legal workers from engaging in platform work. In the forum, participants also looked into the formulation of a standard contract and the possibility of assigning orders in a fair manner. These are also covered by the amendment of Mr. Wai-keung. The work mentioned above, that is, clamping down on illegal workers, the government has been dedicated to clamping down on platform workers. There is a greater demand for online food delivery services. We will flexibly deploy manpower to mount intelligence-based operations. Joint operations will be undertaken if need be to combat offenses relating to illegal workers, including those who work for food delivery platforms. The Immigration Department will also have regard to the trend and modus operandi of crimes and remain in close liaison with platform work. We will require identity verification of delivery workers on the part of platform workers in order to ban illegal workers from using the account of another person to engage in food delivery. Strict law enforcement aside, the government will of course continue its publicity to remind companies and the public not to employ illegal workers. On the timetable, we will put in place a tripartite communication mechanism to explore a way that is suitable for Hong Kong. We are consolidating and analyzing the survey findings. Information and views mentioned above at full steam. We expect to complete it in the first quarter next year. We will report the consolidated findings to the panel on manpower in due course, which includes the direction that we suggest, say non-legislative means or legislative means if need be the relevant legislative timetable. We will report to the panel on manpower next year altogether. Digital technology develops by leaps and bounds. It is believed that the demand for platform services will just rise in the future. It is important to balance the development of the industry and the interests of workers, and to balance the responsibilities and protection between platform companies and platform workers. We'll continue to promote the protection of platform workers full steam ahead. We'll also seek the most feasible solution through tripartite coordination involving platform companies, labor groups, and so on. Thank you, President.
I now call upon Mr. Kwok Wai-keung to move an amendment. President, I move my amendment. I propose the question to you that Mr. Kwok Wai-keung's amendment be passed. Mr. Tommy Cheung claims division. The division bell will ring for 5 minutes.
開始表決。
Voting begins. Professor William Wong. Please check your votes. If there are no questions, voting is closed. The results are displayed. From EC, 38 present, 7 for, 2 against, 29 abstaining. From GCs, 47 present, 11 for, 10 against, 25 abstentions. The question is not agreed by majority of each of the two groups of members present. I declare the amendment passed. Mr. Ari Lee. President, move that in the event of further division being claimed in respect of the motion on protecting platform workers or any amendments thereto, this council to proceed to divisions immediately after the bell has rung for 1 minute. Will those in favor of Mr. Ari Lee's motion please raise their hands? Those against, please raise their hands. I think the question is agreed by majority of each of the two groups of members present. I declare the motion passed. I order that in the event of further division being claimed in respect of the motion on protecting platform workers or any amendment thereto, the council do proceed to each of such divisions immediately after the bell has been rung for 1 minute. Dr. Edmund, you may move your amendment. I move my amendment, President. Mr. Tommy Chung claims division. The bell will ring for 1 minute. Voting begins. Please check your votes. If there are no questions, voting is closed. The results are displayed. From EC, 38 present, 34 for, 4 abstentions. From FC and GCs, 47 present, 37 for, 3 against, 5 abstentions. The question is agreed by a majority of each of the two groups of members present. I declare the amendment passed. Mr. Michael Luk, you have 1 minute 30 seconds to reply. Then the debate will come to a close. Mr. LUK Chung-hung. President, I thank 25 members for airing their views in this debate. I feel that this Council is really concerned about the welfare of the platform workers, and we acknowledge their hard work and contributions. And from many members, I understand that we acknowledge that platform workers' rights should be protected. The government must not shun its responsibility. On matters such as clarifying their legal status or finding ways to give them protection, the government should not drag on its feet. There are many examples from around the world and from our country for us to consider. I hope that this task can be completed within the end of the term of government so that platform workers can get the protection they deserve. I also appeal to members to support my motion and Dr. Amin Yu's amendment. I now put the question to you that Mr. LUK Chung-hung's motion as amended by Dr. Edmund Yu be passed. Mr. Tommy Chung claims division. The division bell will ring for 1 minute.
開始點。
Voting begins. Please check your votes. If there are no questions, voting is closed. The results are displayed. From EC, 38 present, 33 for, 5 abstentions. From FC and GCs, 47 present, 38 for, 3 against, 5 abstentions. The question is agreed by a majority of each of the 2 groups of members present. I declare the motion as amended passed. The Council will be adjourned until the 4th of December 2024 at 11 a.m.